This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a bad faith setup failed in California because the plaintiff failed to provide adequate information to convince an insurer to pay its policy limits, and why inadequate medical authorization forms was used to cause the insurer to refuse the settlement demand. Karen Flick appealed from the judgment after a jury rejected her claims for breach of contract and breach of the implied covenant of good faith and fair dealing. Flick contended that the judgment should be reversed due to juror misconduct. In Kara Flick v. United Services Automobile Association, the California Court of Appeals on November 5, 2024, resolved the dispute over the juror's misconduct and over the issue of bad faith. After sustaining injuries in an automobile accident caused by Francisco Reyes, Jr., Flick had her attorney send Reyes Insurer, USAA, a letter explaining the severity of her injuries and an authorization for the release of her medical records. Flick's attorney followed up with a settlement demand 2 months later, requesting that USAA pay Flick the entirety of Reyes's $100,000 policy limit in exchange for a release of liability. Attached to the demand was a single medical record from Flick's neurologist. USAA investigated Flick's claim and determined it did not have sufficient information to accept or reject her demand. Flick then filed a personal injury lawsuit against Reyes, and the jury found in her favor and awarded her nearly $1.7 million in damages. Flick, with an assignment from Reyes, sued USAA for breach of contract and breach of the implied covenant of good faith and fair dealing, since he had no way to pay the full $1.7 million in damages. At trial, USAA's claims adjuster admitted that Reyes was fully at fault for the accident with Flick. Reyes could therefore be exposed to liability in excess of his policy limits if Flick provided sufficient documentation to support her claim. USAA's expert on insurance claims handling and another of its claims services managers both agreed with the supervisor that Flick's authorization was invalid as provided and inadequate to allow USAA to obtain Flick's medical records. USAA needed additional records before it could determine the value of Flick's claim. Those records could have included the medical bills Flick provided in her own to her own insurance company, the multiple doctor's notes she had excusing her from work, or the thumb drive recording her purported speech problems, all of which were entered into evidence at her personal injury trial. Because they were not provided to USAA before the trial, it was very difficult to place a value on Flick's claim. Flick's expert testified that USAA's handling of the settlement demand was clearly unreasonable and was countered by USAA's expert. Flick also did not respond to USAA's multiple requests for additional information. By a vote of 9-3, the jury found Flick did not make a reasonable settlement demand of USAA and rejected her claims for breach of contract and breach of the implied covenant of good faith and fair dealing. The trial court polled the jury, and each juror confirmed their vote. The Court of Appeals concluded that the trial court did not abuse its discretion in denying Flick's new trial motion. USAA successfully rebutted the presumption of prejudice by showing there was no reasonable probability that the juror DC's misconduct by not explaining he did not hear all of the adjuster's testimony actually harmed Flick. Much of the adjuster's testimony consisted of facts regarding his communication with Flick's attorney, facts that were undisputed. What was disputed, whether Flick's settlement demand was reasonable, was the subject of other witnesses' testimony, including USAA's expert on insurance claims handling, its supervising claims service manager, Flick's personal injury attorney, and her expert witness on insurance claims handling. What the admitted evidence showed was that DC confirmed multiple times that he voted that Flick did not make a reasonable settlement demand, and based on the record, there was no reasonable probability that DC's alleged juror misconduct actually harmed Flick. In my opinion, the tort of bad faith arose from abuse by insurers on those they insured. Since its adoption in California about 3/4 of a century ago, the abuse has been turned on to insurers. Ms. Flick's counsel placed a demand for settlement on USAA that it could not reasonably and in good faith to its insured, Mr. Reyes, except because it was incomplete and inadequately supported, and forced Flick and Reyes to go through a trial where she received an uncollectible judgment against Reyes in hopes of a gigantic bad faith and punitive damages judgment. After much litigation and USAA spending a great deal to defend itself, she received the $100,000 policy limit and nothing more. USAA was punished, but neither Flick nor her lawyers profited from the scheme or the appeal. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5 or 6 a week. You can also have access to the more than 4,900 blog postings. If you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. And please tell your friends and colleagues about the blog and the videos. They're all free and are available to anyone. Thank you for your attention.